It didn't take long for the narrow interpretation of the Hobby Lobby ruling to get that much broader. Just a day after the decision, and a day after Ruth Bader Ginsburg's dissenting opinion that the court has stepped into a minefield, that minefield has literally begun to blow up in our faces. Now, Mother Jones reports that the Supreme Court had ordered the lower courts to rehear any cases where corporations had sought to deny coverage for any type of contraception. Now, that's important because it's for any method of contraception, not just the 3 or 4 cases Hobby Lobby was opposed to and appealed on. Okay? Now, didn't I warn you guys after the ruling that this would allow corporations to deny all contraception coverage to female employees? Now, I kept getting comments on a video I did on the day of the ruling telling me how narrow this ruling is. Oh, but Jeff, this ruling only prevents corporations from having to cover abortion pills if they're religiously opposed. You know, it covers the abortions. It stops, them from having to pay for killing babies. First of all, you're a fucking moron and don't know how contraception works at all. So you should shut the fuck up right there. But no, they're also saying they're just protecting religious freedom. Bullshit. Now companies can officially choose not to cover any of the 20 different forms of contraception that had to be covered under the ACA. Now they can claim a religious objection to any of them. But hey, corporations are people, my friend, with speech and religious rights that now trump yours. Look, if you didn't think that this was going to get worse, you guys weren't paying attention. This is not a victory for religious freedom. Once again, and I said it before, it's a victory for corporate personhood. Now, what do you guys think of this broadening of the ruling?
Okay, so first thing I want to break down is it hasn't broadened yet. There are people that are trying to make it broader, but the ruling is still narrow. Like Ruth Bader Ginsburg's or her minority interpretation of the ruling is the minority interpretation of the ruling. It's not the general ruling. So they're going to rehear these cases, and even if they rule that all companies that fit in this category, which is, I believe, a small group of people that own 50% or more of the stock, can deny contraceptive care or certain amounts of contraceptive care or every contraceptive care, that still isn't as broad as people think it is. So it's
but you got to look at the precedent that it's set. And because the ruling has set a certain precedent, you've got a lot of other companies that are coming in already and saying, hey, we want the Supreme Court to hear our case. Based on the Hobby Lobby ruling, we should be able to deny our female employees contraception that we are morally objected to.
Right. I got that.
Breaking down the entire birth control mandate.
Well, I mean, in my opinion, first of all, the religious thing, that you have a religious exemption, that's for churches, whatever, that's an argument to be made. But for business owners, I don't see the point of a just moral religious exemption, that you have to have a genuine, I forgot what the exact word that they use, belief.
A closely held religious belief.
Right. I think that's ridiculous, but I also think that the mandate is not logical. I think that the employer and the employee have to come to an agreement on what type of compensation that they have, and a healthcare package is included in that. So I don't like this special religious thing that's unprovable, what's inside your heart and how you feel in the Hobby Lobby case. But the reaction to this case is what I'm trying to work my way around to. The original part of the case is ridiculous because it hasn't happened yet that they've ruled that all these companies can deny coverage. 2, even if they did rule that, you gotta there's nobody forcing you to work for that company. You could go somewhere else.
No, Sean. The court went and said, by the way, you can now appeal for a religious exemption.
You can appeal. They want them to rehear and rejudge based on that precedent. So they want the lower courts to interpret the higher court ruling. Because there are certain cases that weren't Hobby Lobby cases, that didn't get accepted into the Supreme Court that they want them to review. But that doesn't mean that all contraception won't be covered. And even if all contraception is not legally obligated to be covered, that's not a huge deal. Like, I'm sorry. Like, you don't have the right to free birth control. You don't have the right to free anything. Like, I want birth control to be available. I advocate for it being over the counter in all the forms where it's perfectly safe. The government requires women for no reason to go through an invasive exam to get prescriptions for things like the pill it doesn't make any sense. But like the idea that you have a super right that allows you to force employers to provide something to you is ridiculous, and I don't agree with that. So I don't agree with the ruling, and I don't agree with the people who are outraged at the ruling at the same time. Suck on that.
No, not buying it, dude. I think that everybody does have a right to control their own, reproductive organs.
Yeah,
I'm sorry.
You can. I'm not saying ban it, but you can't force other people to pay for it. Like, that's a super right.
Okay, no, because the problem with that is if you society pays for unwanted children anyway. Either way, you're paying for it. So why not do the fiscally responsible thing and have insurance companies pay for the birth control? Remember, like if you're an employee, you're also paying for that insurance through the company.
Right, but first of all, your argument is because the government created a welfare system that it can't maintain, then they should restrict people's freedoms. That's ridiculous. Number two, the government is the one who incentivizes you to get.
Okay, who's
the government incentivizes you to get your insurance from your employer instead of giving you the same tax breaks for buying your own plan, which is also ridiculous. There's no reason that should be the case.
Okay, so whose rights are being restricted? A corporation doesn't have rights. Okay, as a business owner, I get that you have your own certain religious rights, right? If you don't, if you don't want to take birth control, that's fine. Like, that's your religious right. But as a company that provides a service for employers, these employees should be able to choose what their insurance company covers.
But what if you only have? What if your employer offers you a healthcare plan? One covers everything except contraception, and it's half the price of the plans that do cover contraception, but are missing other things. Like, as an employer, you're paying for part of that plan. You have the right to pick which one that you want to provide to your employees.
Sean.
Hold on. As an employee, you have the right to work somewhere else, buy your own plan, pay for your contraception out of pocket. Like, you have all these different options. Like, this ruling doesn't necessarily restrict contraception. Like, it's ridiculous, the religious aspect of it, but like the concept that you have the right to obligate somebody else to pay for your stuff is also ridiculous.
But Sean, here's the problem with that. The companies who appealed the decision, like Hobby Lobby, aren't the ones offering a health insurance plan that has everything except contraception. They're companies that are offering probably the bare minimum that they're required to offer, and that's as far as they want to go. Now, okay, you can disagree, and I'll hear your rebuttal on this. But first, I just want to say that I'm not as certain as being a man. I'm not entirely certain quite how it works up here in Canada, but I'm fairly sure we have our contraceptive at least partially covered by, if not health insurance from our work, then by our at least in Ontario, our Ontario Health Plan, which allows us to have certain medical expenses written off on taxpayers. But so the idea to me that a company shouldn't provide contraception to its employees if the employees can't afford contraception on their own, or as part of a deal that makes it more or easier to acquire, easier to get. I don't know. I don't quite buy it. It's one thing if the employee has the same views and says, okay, I want the plan, I won't do the contraception thing, that's fine. I disagree with the very fact of taking away the option in the plans, though. If, as a company, and sure, as the head of it, you have the right, clearly through the recent court ruling, the head of a company has that right to do that. But I don't think morally speaking, if we're going to go for the moral argument, I think they're morally reprehensible for taking that approach, because the moral approach would be, here's the option. I disagree with you if you take it, but I'm not going to be that much of an asshole to take it away from you.
First of all, the Hobby Lobby healthcare plan covers 16 of 20 contraceptive options. The ones that they don't cover, one of them's Plan B, another one is an emergency contraceptive. The fact that that's covered by insurance is like completely unnecessary anyway, because if you're in a situation where you need to take Plan B, like, it's over the counter and you should get it as soon as possible. You shouldn't go to a doctor, make an appointment, get a prescription, then go get it. Like, it's $50, sometimes $40, sometimes $60. I don't want to get personal on how much I know that, on how the reasons I know that, but like, you want to take that immediately. Like, there's no reason for you to go to a doctor for that. So that's not an undue burden in cost, in my opinion. I get that some people might have that, like, that might be a lot, but it's better than a pregnancy or an abortion, which is like $500. Also, the IUD isn't covered. The IUD is $500 to $1,000, which is very, very expensive. I'm not going to say that people shouldn't be upset about that if they want it, but if you compare it to what the pill would cost or what anything else would cost, and factor in that an IUD can last from 5 to 12 years, then like, that's really not that expensive. It's $500 to $1,000.
Well, when you think about it, but that is a huge upfront cost, and the thing about that is that with birth control is that it's not one size fits all. Okay, is that you have so many different options of different birth control methods because it's necessary, because not all women are the same. Not all women respond to the same level of hormones that are in those birth control methods. So that's why you're supposed to have all these different options. And the whole religious exemption is based on faulty science. But they believe that those things are abortifacients, okay? They believe that they cause abortions. The whole ruling is based on a faulty presumption, on faulty science, and that's one of the reasons that I mostly disagree with this ruling.
Well, I disagree
from reality.
I disagree on the religious exemption and all that, but the thing is those three options plus like one more that's another, like, a longer term one, right? Like, those are the ones that are banned or that aren't banned. Those are the ones that you can't get through your insurance if you work at one of these weird corporations that has a few employees that control 50%. It's a long, complicated thing for you to be exempt from those requirements. But they still are 80%, and all those different types you can get on, and they'll work with you and all that. Like, you could do trial and error. There's no reason like why Plan B and like the other one, like, those are emergency contraceptives, so they don't really need to, like, those don't even count as like a long-term plan, like a long-term family planning thing, in my opinion. So like, it's really 90% of the types are covered.
The challenge of this is also the fact that it sets a precedent. And we can tell the precedent is set is a very negative one based on the number of court appeals now coming forward that are looking at the Hobby Lobby decision and trying to appeal further to get more concessions out of this. And that's the problem. That's the problem where if you give ground on even some of this, I know it's usually slippery slope arguments aren't good, but we're seeing the evidence that it actually is a slippery slope in this case. It's coming back to bite us in the ass. More and more people are trying to apply for more and more exemptions to this ruling. They're trying to get more out of it so they can cover less and less. And that's
the minefield.